Alex, can you tell me about that case I recently just sent you from the Massachusetts District Court? I think it's a case against Restoration Hardware. And I saw it come up quick on my computer, but I wanted to talk to you about it.
Certainly. It's a pretty interesting case, actually. What Aetna did in this case, I mean, the guy worked for Restoration Hardware. He had a policy with Aetna for long-term disability insurance benefits. And what Aetna did here was just, it's kind of ridiculous. When you hear the story behind the claim, it's kind of, you're going to roll your eyes like, that is just ridiculous. So this guy worked for Restoration Hardware. He just started working there, actually. He started working there on May 12th of 2014. So just a little bit of background. Prior to his hire, he went to his primary care physician because he had a lesion on his back. Primary care physician says, hey, it's probably a basal cell carcinoma, which is a very basic thing that can be easily removed, and that's all you have to do to treat that condition. His doctor says, I don't know what it is, let me send you to a dermatologist. So the guy starts working for Restoration Hardware on May 12th. He's told that his long-term disability insurance effective date is June 1st of 2014. In mid-June, he finally sees his dermatologist. Dermatologist says, hey, let me take a look at it. He does a biopsy on it and says, actually, that's a malignant melanoma, which is way more serious than the other condition. Malignant melanoma, basically, you have to get it removed, then oftentimes you have to do chemotherapy, a lot more intrusive, a lot more debilitating. So he has the treatment done. Lo and behold, he ends up stop working in September just because of his the impairments caused by his treatment. You know, sooner or later he just cannot work anymore just because of everything that he's going through. Now his policy just covered. So his policy is what's known as a pre-existing condition clause, and as you're well aware, they're in most long-term disability insurance policies, if not all of them. And they essentially state that they will not pay you benefits for certain conditions if they're pre-existing if you make a claim under the first year of the policy, that you're covered under the policy. Specifically, this policy states that what's considered a pre-existing condition is a disease or injury is a pre-existing condition if during the 3 months before the date you last became covered, it was diagnosed, treated, or services were received for the disease or injury, or you took drugs or medicines prescribed or recommended by a physician for that condition. So, comes disabled, files this claim for disability benefits. The first person at Aetna that reviews the claim takes a look at it and says, I don't think it's pre-existing, I think he's disabled, I'm gonna say we should approve this claim. That person gets overruled by someone higher up at Aetna. The higher up gives no reasoning whatsoever why they're overruling that person, says, nope, this is pre-existing, denies the claim. Lavery files an appeal. The appellate, when it goes to appeals, it's sent to another consultant. That consultant looks at everything and says, I don't think it's pre-existing either. This is a different diagnosis. This is malignant melanoma. He didn't get treatment until after his date of disability, and the treatment is what caused him to be disabled. I don't think it's pre-existing at all. But again, that person gets overruled. So now two people have recommended payment of benefits and came to the conclusion that it was not pre-existing, have been overruled, and no one knows why they're getting overruled.
And this is Aetna Insurance Company?
This is Aetna Insurance Company.
So this is kind of like the claims person looks at the claim, and then they always have to have it approved by a supervisor.
Exactly.
So both supervisors are overruling.
Exactly. The supervisor says it's pre-existing, and also the supervisor says, hey, listen, as of May 1st, 2014, the policy was actually changed a little bit. Now the policy states that in order for you to be covered under the policy, you have to go through a 30-day probationary period. So that means if you're hired on May 12th, back at the previous policy states that you become covered as of June 1st, the first of the month, the next month. Now the policy has been amended that states that you don't get coverage until the 30-day probationary period's over, then the following first of the next month. So they're saying, now your coverage didn't begin until July 1st of 2014. The funny part about that is that although it went into effect on May 1st, this new provision of the policy, it actually was not published, and the new policy was not published, and it says a published date of June 23rd of 2014. So there's no way that Lavery or anyone else that was hired in that time period could actually know that there was a new provision of the policy saying your coverage didn't begin until July 1st. So a lawsuit's filed. He's out of appeals, a lawsuit's filed. Luckily, the judge in this case in Massachusetts smelled through all the BS and found in favor of Lavery and ruled against Aetna. So the judge thought a few things. One, that obviously that it was not pre-existing. the judge realized that, yes, he saw his primary care physician in April prior to his even being hired, but the judge noted that there was no diagnosis, there was no treatment, there was no services received or rendered, there was no drugs or medicine. The doctor just said, the primary care physician just said, go see a dermatologist. So the judge says this is not pre-existing at all. The judge notes that a diagnosis actually comes out, malignant melanoma. That's a very serious condition. The judge finally states that the game that Aetna is playing regarding the effective date of coverage, it's a joke, because there's no way that Lavery could have known that he actually wasn't covered until July 1st, because the publishing of the new policy was not until June 23rd, 2014. So the judge said, if he would have known about this, the guy could have waited until July 1st or July 15th to actually get coverage, or actually get treatment for this condition, or actually see the dermatologist to figure out what's going on. But there's no way for him to know it, so he was kind of getting screwed here. Aetna was trying to screw him by not only overruling their two people that recommended approval, Aetna also tried to screw him, saying, "Oh, you're not covered. Things have changed now." So it was kind of a ridiculous denial, and thankfully, the judge saw through the BS. And I see a lot of cases that are pre-existing, and they're always so hard to win that they scare me off a lot of the times. But this case is a great case that the judge was not scared off. And thankfully, it's a case that we can all learn something from, that just because you see pre-existing, or the insurance company tells you that your case is pre-existing, does not mean it to be true.
Right. I mean, in every case we see, the first thing the insurance company does when they get a file is to do a pre-existing condition background check, basically,
Exactly.
to see if it's going to fall in there. So I think this claimant got lucky in the sense to get around the pre-existing, because it seems like if what he had 30 days before was probably the same thing 30 days later.
Right. I mean, another judge might call this pre-existing, to be honest with you. They might say that, listen, while you didn't get a diagnosis or treatment, services were received because you had a doctor look at it. So this is a close call, and this guy's very lucky to get on claim.
Right. And then the games that Aetna plays is, I mean, Hartford just bought Aetna.
Right.
Well, not just, but just within the last 7 or 8 months, and so we're still seeing some of the same Aetna people on the claims, and we'll see if those kind of behaviors continue. But Hartford does the same shenanigans as well. It's just like if they have any opportunity to deny a claim, they're going to deny it and ask questions later.
Right.
This one is exceptional, though, like you said, where 2 different supervisors overturn it. It's almost like they're getting bonuses based upon the amount of claims they deny. I can't verify that, but it would be horrible if they are. But what they kind of feel, they have this inherent conflict, because if the company's paying out more money, then there's less money to potentially profits for the company, and probably less bonuses available for them, which is it's not going to be written down on paper like that, but it sounds like, why would 2 different supervisors want to reverse it?
It's crazy. And maybe the judge saw that and saw this is just BS. They're treating this guy terribly. Aetna people are actually approving this claim, so why should I not approve this claim?
Well, we do a lot of cases in the Massachusetts court, and it's good to see that there was a reasonable judge who looked at it favorably.
Sure.
Obviously, anyone who has this kind of claim can call us for a free consultation. We'll review the claim with them, let them know right away whether or not we can help them. And thank you for educating me on this case. And it's obviously not a case that we handled, but we track every single case as they come out every day when they're reported through the channels available to lawyers. And we'll continue to report on these, and hopefully this is helpful to any disability claimant out there.